Hey y'all, Rob here with ATX Legal. Here is part 2 of the DWI guide, and this one focuses on bond and jail release. Now, of course, that's the very first thing that you're worried about after you've been arrested is how do I get out of here? Now, fortunately for misdemeanor DWIs, usually the case is that a PR bond will be granted by the magistrate judge and you can be released without having to go through a bondsman, and the process happens relatively quickly, although you usually will spend overnight in the jail. Usually by 10, 11, noon the next day, you are going to be released. Now, there are some exceptions, which I will talk about later. Now, the first thing to keep in mind is whether you've been arrested in Pflugerville or anywhere in Travis County, you get taken downtown Austin to 500 West 10th Street, down to the jail there, and that's where you will be held. They have a magistrate in the jail who will magistrate you right there. And when I talk about magistration, what I'm talking about is the judge is going to read you your charges and set your bond, and then at that time can make the determination to grant you a PR bond. And they'll make that determination based on a packet that pretrial services goes over with you. They're going to ask some basic information from you. Sometimes they're going to want a contact that they can reach out to basically say, hey, is this person going to make it back to court? Because that's what your bond is doing. It's securing your ability to come back to court. So if a PR bond is granted, it's basically free of charge. There's like a $25 fee that you'll pay later, but it's basically free. You get released, and then if you miss court later, then it would be a revocation of the PR bond, and at that point, you would owe money. But assuming you come to court and handle everything in the proper way, you won't ever really pay anything other than that $25 fee on the PR bond. So you may be thinking to yourself, that's great, I don't need to hire an attorney. And that's true. You would be able to get a PR bond in a lot of cases if you don't hire an attorney. But if you do hire an attorney at this stage, what he or she can do is come in and waive magistration, which means you don't have to wait for that judge. So magistration in Travis County usually happens around 10 a.m. in the morning, and then I think they do a couple more, one in the afternoon and maybe one at night. It's basically whenever the magistrate wants to do it. If you hire an attorney, I can say you don't have to wait for the judge to come tell you your charges. I'll go ahead and take that PR bond to the judge, and you can get released 5-6 hours sooner. So for some people, that is going to be worth it to go ahead and hire that attorney. The logistics of it are a little bit tougher because you are not going to have access to your bank account. You're going to need to have someone who is a friend or a family member who can put up the money to hire the attorney. But for a lot of people, it is worth it to get that 5 or 6 hours of freedom back that you'll never get back if you are waiting in jail. Now, there are sometimes facts which are going to prevent you from getting a PR bond. And what do I mean by that? Well, if there was a significant accident, for example, where people got injured, maybe the judge is going to be more reluctant to release you. If your BAC was extremely high, 0.3, something like that, the judge might say, no, I'm not going to release him. We need to get a plan in place before I release him. There are other factors. If it's a felony DWI, it's going to be a lot tougher to get a PR bond. In fact, at that point, you really are going to want to get an attorney to secure a bond, because it's not likely that the judge is just going to say, I'm going to give you a PR bond right off the bat. An attorney can go in later and sort of bring other facts to light. Maybe even though it's a felony DWI, the facts on this one aren't as severe, so that a PR bond would be granted in that case. But this is definitely a case where a hired or retained attorney is going to help you get that bond and get released. If you don't get a bond, you could potentially be waiting in custody until your case goes to trial, which could be 6 months, 12 months, 18 months from then. So you're definitely going to want to look into getting an attorney who's going to be aggressive about getting you a bond. If you don't qualify for a bond, and remember we're talking now about severe DWIs or felony DWIs, then you may qualify for a cash or surety bond. And at that point, you would probably need to go through a bondsman where you would pay about 10% usually of your bond. Sometimes the bonds are set at $20,000, sometimes they're set at $10,000, $5,000. So do the math, that would be $500 to $2,000 that you would pay to a bondsman to secure your release. There are a lot of bondsmen around the courthouse. ATX Legal does not endorse any of them. I would just recommend calling around, seeing where you can find the best deal. And one last thing to keep in mind is if the person who is arrested has been in custody for several days, they're going to usually transfer them from downtown to the Travis County Correctional Complex, which is in Del Valle. So if you are posting a cash bond, you would need to physically go to the Del Valle location. There is a phone number in the guide to find out where the inmate is being held. So just be sure to call that number before you go to post the bond, otherwise you're going to waste a trip. Okay, now let's talk about bond conditions. The judge can put on any condition on bond that he or she feels is necessary to get the person to come back to court or for the safety of the community. Now, in DWI cases, by far the most common condition on bonds is the ignition interlock device, or the IID. This is a device you put onto your car. You have to blow into it before you start the car, and you have to blow into it periodically while the car is driving. So the cost is usually about $75 a month. It varies a little bit from vendor to vendor. Plus there is an installation fee, and you do have to pay those costs out of pocket. An IID is not required on all DWIs. If it's a Class B misdemeanor, the judge might not include it as a condition. If he or she does include it as a condition, usually after 3 months on a Class B misdemeanor, I can go in and request the judge to remove that, assuming there have not been any violations on the IID. Now for Class A's, where it's above a 0.15, or for felony DWIs, it's required by law that you have an IID or another device, which we'll talk about later if you don't have a vehicle. There's really nothing that your attorney can do about it to get the judge to take that condition off. So just kind of the shorthand is, for the severe DWIs, you're definitely going to have the IID. For the sort of mid-range misdemeanors, you may or may not have it, or your attorney may be able to get it off. Now, one thing that will happen sometimes is my client will not have an IID. The blood results will come back and they'll be above a 0.15, and now the judge and the prosecutor will bring us back to court and they'll add that condition onto your bond of the IID. So it's a hassle. Nobody likes having that in their vehicle. Sometimes there's things that your attorney can do to get it off. Other times you're going to be stuck with that IID and you're not going to be able to get it out until your case is handled. Now, the silver lining of that is a lot of times if you have no violations on your IID, it can actually help with your case and with the plea negotiations, and you can get credit for those months that you've had the IID with no violations. Usually, if you do get even a single violation and we can't write it off as a mistake, that's going to restart that clock and you're going to lose all the credit that you had before that. So it's very important that you maintain no violations on your IID. It can help in a lot of ways. Now, there are two other devices that can replace the IID. For a number of reasons, I don't recommend either one of them, but sometimes they are necessary. So the first one's called the Portable Alcohol Monitor, or the PAM device. This is a small handheld device that you carry around with you, and you have to blow into it on a schedule. And at first you might be thinking, oh, that sounds a little better than the IID, which is in my vehicle. But when it comes down to it, nobody really likes to be on a schedule. Most people, it's just human nature. You're going to miss a blow here or there. Those all count as violations. Sometimes you're going to have to take a break at work just to go blow. You want to be inconspicuous. Sometimes you're going to be sleeping and you have to wake up, blow into the device. It's really obnoxious. You don't want to do it. They only really include this as a condition typically when a person's vehicle doesn't work or they don't have a vehicle and they need to have the portable alcohol monitor as a replacement. So it's more expensive than the IID as well. So there's a lot of reasons that the PAM device is not recommended, but we still have to do it in some cases where a person just doesn't have a vehicle. And the last device is the worst of all. It's called the SCRAM device, Secure Continuous Alcohol Monitor. This is a device that fits around your ankle. It's on your ankle at all times, and it monitors your alcohol consumption at all times. It's very expensive. However, this is the one device where we can ask the judge to order that the county pays for this device. So for my clients that just absolutely can't afford an IID or a PAM, the SCRAM might be a consideration there. However, just think about this. You don't really want a device on your skin at all times. You have to be careful in the shower because you can't get it wet. You can't go swimming. It can cause a rash. It's a very intrusive device. You really want to avoid this. I have seen cases where in felony DWIs, the judge has required an ignition interlock device and a SCRAM device. That's especially burdensome. I haven't seen that much, but for severe cases where the judge is like, look, this is the only way I'm going to release you, sometimes that's your only choice. So the shorthand is just avoid the SCRAM, avoid the PAM. The IID is the way to go, even though it is annoying. It's the least burdensome of the three choices. Okay, so bottom line is when you're arrested, your first priority is obviously getting out of custody. If you're a loved one or a family member watching this video, you can visit us at atx.legal or call us. We can go down to the jail, waive that magistration, get your loved one out a little bit quicker. Or if they're in custody longer on like a felony DWI and you really need help getting that bond, you can visit us at atx.legal and set up a consultation there. None of this is legal advice, but if you do want legal advice on your case or your loved one's case, you can visit us at atx.legal or call us and set up a free consultation. Thank you.